और ये सो मोटो डिक्लेरेशन है या कोई केस फाइल होने के बाद है ये डिक्लेरेशन?
Now, this is again very interesting because in some judgments in Sher Alam's case, for example, the court says that a writ for quo warranto can be filed, and that obviously comes in constitutional jurisdiction. And in fact, this court can take suo motu notice under 184(3) and gives
quo warranto. वो तो Article 199 में it is totally different.
बिल्कुल.
The person has to show under what authority of law he is enjoying the office.
That's right, sir.
But वो तो office में जाने के बाद है, not prior to the
office में जाने के बाद होगा. But as far as that declaration is concerned, question is, can that declaration be given in those proceedings, or for that somebody has to go to civil court or some court which has the original jurisdiction to try and receive evidence, allow the person against whom an allegation has been brought to cross-examine.
एक चीज जरा देखिए, come back to Article 62. Read G.
He has not, after the establishment of Pakistan, worked against the integrity of the country or opposed the ideology of Pakistan.
Yes. Now, if we read 62(1)(g) on its own with the judgment of Samiullah case, the ban is lifetime ban.
But
if we read them together. Now read 63(1)(g). It's the same language, ideology of Pakistan.
For propagating,
and here it prescribes a ban for 5 years.
Or the sovereignty, integrity, or security of Pakistan.
So it's the same 62(1)(g) and 63(1)(g) are more or less similarly worded.
That's right.
It is working against integrity or opposed to the ideology of Pakistan.
That's right, sir.
Now, if we apply Samiullah Baloch to 62(1)(g), it is lifetime ban. And if we apply 63(1)(g), it is 5-year ban. Unless you say 62(1)(g), Samiullah Baloch is not attracted to 62(1)(g). That could be one argument. So
it's interesting what my lord has observed, because if a person is dishonest और उसके खिलाफ मुकदमा दर्ज हो जाए और उसको सजा हो जाए, तो फिर 2 साल काटने के बाद 5 साल बाद वापस आ जाएगा. मुकदमा ना हो और पता नहीं क्या हो और एक declaration आ जाए, तो then he's gone.
If he has been convicted and goes to jail, so his sins are expiated, right? And he's okay.
Yeah.
Now, if he is, for instance, acquitted or is not even prosecuted, then he is lifetime banned. So I find it difficult that a court of law which has convicted a person, meaning your guilt was established 100%, you are banned for only 5 years. And if your guilt has not been established, because every criminal case has 2 components, conviction and sentence.
That's right.
You can be convicted and you can be sent on parole, or you can be convicted till the rising of the court, or whatever it is. Or maybe not, say for good conduct, we don't convict you this time, we don't sentence you this time, we just convict you.
That's right.
So that will be a lifetime ban, and the person will say, can you please send me to jail so I can contest elections again after 5 years?
Yes, I would rather the rising of the court so I can just go back after 5 years.
So see, certain things are very clear. You are a citizen of Pakistan. I mean, I find okay that it's pretty clear. There may be some gray areas where you may be holding 2-3 nationalities or whatever the case is, or you may have given up or whatever. But generally, age is a determinative factor. It's clear. And then we come to D, E, F, and G, which are vague. And they're overlapping as well, because it says is of good character. Now, can any human being possibly say this on oath if he's truthful? If he's truthful.
So it appears that as far as D, E, and G is concerned, there's no third-party declaration. You know, who's actually saying that he doesn't have adequate knowledge of Islam? Who's saying that he's said anything against the integrity of the country? So there's no third party, right? So how does the disqualification work? On that election, and then it forgets about it, and then the next election he can contest? I mean, we found out that he doesn't have adequate knowledge of Islam. 20 years ago, and he missed the elections that time. Then he's now become a saint, perhaps.
Alim.
An alim. And then what happens?
Hafiz, alim.
So ایک تو وہ سمجھ نہیں آ رہی, لیکن فرق صرف یہ ہے کہ ایف میں تو یہ ہے کہ ایک ڈیکلیریشن کھڑی ہوئی ہے تھرڈ پارٹی کی, تو جب تک وہ کھڑی ہوئی ہے وہ چلتا رہے گا. That's what Samiullah Baloch saying. Samiullah Baloch actually turns on a declaration.
وہ ہوا یہ کہ ایکچولی 18th امینڈمنٹ میں یہ جو ڈیکلیریشن بائی کورٹ آف لا لانے کا پرپز تو یہ تھا کہ وہ ریٹرننگ آفیسر جو ہے نا وہ ڈٹرمن نہ کرتے رہے یا اس قسم کا ایلیگیشن کوئی اور رینڈملی نہ آ کر لگا دے, اور تاکہ یہ جو ڈی ای اور جی کے اندر جو ہو سکتا ہے وہ ایف میں نہ ہو.
آپ کے مطابق
الٹا ہو گیا.
how does DE and G play out actually? I want to ask this question. آج سے 10 سال پہلے کسی نے انٹیگریٹی آف پاکستان کے بارے میں کوئی بات اسپیچ کر دی, بس ختم ہو گئی بات, اب وہ الیکشن نہیں لڑ سکتا.
یہ دیکھیے کچھ لوگ ہوتے ہیں تو انہوں نے 5 years کر دیے, وہ کہتے ہیں یس آئی ہیو سین دی لائٹ. اب اسلام میں بھی توبہ کی گنجائش آخر منٹ تک ہے. وہ کہہ سکتا ہے جی مجھے, جیسے مائی لارڈ نے آبزرو کیا کہ مجھے اسلام کے بارے میں نہیں پتا تھا, اب میں نے سارے اب لائف ٹائم بین اس کو کر دیا کہ وہ پھر شاید حافظ بن گیا ہو سکتا ہے, عالم بن گیا ہو سکتا ہے, آپ اور بہتر اور ہم سب سے بہتر قرآن شریف سمجھنے لگا ہو, اور وہ لائف ٹائم بین میں آ گیا کیونکہ اس کو 20 سال پہلے یا 10 سال پہلے یا 5 سال پہلے ان چیزوں کے متعلق علم نہیں تھا.
سمیع بلوچ جو ہے اٹ ایکٹس ایز اے گلیٹین. وہ کہتے ہیں کہ جب آخری اپیل میں جب آپ آئیں گے تو بس اس کے ڈیسیشن سے پہلے تو اگر آپ ریپینٹنس کر لیں تو ہو سکتا ہے, ورنہ ونس that happens then there is no repentance.
کہاں چھوڑا
نہیں چھوڑا 184.3 میں تو ویسے ہی نہیں ہوتا, بٹ ادروائز بھی نہیں.
ریپینٹنس کہاں لکھا ہوا ہے؟
صاحب سننے ذرا, جی صاحب
سمیع بلوچ
دیکھیں اس میں اصل بات یہ ہے کہ ڈفرنس ہم نے معلوم کرنا ہوگا 62 63A میں. واٹ از دا ڈفرنس بٹوین the two? As far as I'm concerned, 62 is not giving power to decide against a person. دیکھیے اس میں تو سمپل یہ اٹ از ڈیپینڈنٹ اپون 63 میں جو کاروائی کریں گے وہ دکھائیں گے, 62 میں وہ کہیں گے یو آر ناٹ کوالیفائڈ, ویئر ایز ڈسکوالیفیکیشن از ان 63. اگر کوئی شخص سپوز کوئی کام کرتا ہے, کوئی غلط کام کرتا ہے, تو اگر آپ جی اور ایچ کو پڑھ لیں, جی اور ایچ وہ ڈٹرمائن کرتے ہیں کہ کورٹ آف لا سے جب اس کو کوئی ڈکلیریشن ہو, یہ اس ڈکلیریشن کی بات ہو رہی ہے, آئی تھنک سو.
جی
اس پہ بات کریں کہ یہ 62(1)(f) کہاں پہ پاور دیتے ہیں کہ آپ اتنے ٹائم کے لیے ڈسکوالیفائی ہو, اتنے ٹائم کے لیے. وہ تو صرف یہ بتاتے ہیں کوئی شخص پیپر سبمٹ ہو رہے ہیں اس سے پہلے بتا دیا کہ یہ فلاں کورٹ سے اس کو سزا ہوئی لہذا پیپر خارج, دیٹس آل, میٹر اینڈز. The authority dealing with this matter have no power to decide the disqualification period of that person. وہ disqualification کے period تو 63 نے بتا دیا, یہ سزا جرم کرو گے تو اتنی سزا ہوگی, اور اس جرم کی سزا پوری ہونے کے 2 سال بعد جب آپ نکلیں گے تو پھر آپ کوالیفائی ہوں گے. تو یہ آپ جو پہلا سوال جو آپ سے کیا کہ ڈفرنس, آپ ڈفرنس جب بتائیں گے تو خود بخود پتہ چلے گا what is 62 and what is 63.
So if 62(1)(f) is juxtaposed with 63(1)(h),
H and H both.
H moral turpitude.
H moral turpitude ہے because وہ اس کے ساتھ dishonesty etc. وہ اس کے ساتھ ہے moral turpitude being very broad, اور وہ ایگزامن ہوا سمیع بلیف. اس کو اگر آپ سامنے رکھیں تو the consequence then, if they are to be reconciled, then the consequence is only one, which is that the timeline which is provided for the declaration in 63(1)(h) must necessarily apply to the time to the declaration 62(1)(f).
H میں اگر conviction ہو گئی because it attracted an offense and so it led to conviction, then he can come back. But if it was lesser than even a case where it could constitute an offense and so he could not be taken in a criminal case, a simple declaration was given on the civil side, that goes on unlimited. اب یہی سمجھ نہیں آتی because otherwise then we also have to stay away from the concept of reading into the constitution.
But now that you have started reading in 63A, so I was just
that is also a question.
So you must stop from reading furthermore.
Reading in
just another aspect if you can attend to. Can you read D?
My lord.
Again.
He is of good character and is not commonly known as one who violates Islamic injunctions.
Now please read F.
He is sagacious, righteous, non-profligate, honest and ameen, there being no declaration to the contrary by a court of law.
Now, what does this mean? There being no declaration to the contrary by a court of law. In clause D, and in clause E, and in clause G, these words are not mentioned.
That's right.
So either you say clause D, E, and G are redundant, they're meaningless clauses, because the words, there being no declaration, either the same wording should have been followed. And I can't, at least I cannot understand the difference between good character and sagacious. I mean, good character is something different from sagacious. Is good character different from being righteous?
Righteous,
non-profligate. What does that even mean? What does non-profligate mean? What does it mean?
Who doesn't spend wastefully?
Israf.
Yeah.
So good character.
Yeah.
So if you are doing wuzu and wasting water, you become a profligate. Because there's a hadith of the Prophet.
That's right.
Do not waste water, and even if you're standing next to a flowing river. So then he's a profligate. So, and then we go honest. Good character, every good character person is an honest person, I would imagine. And Ameen. I mean, you know, these are words which a Muslim would never even dare utter in deference to the Holy Prophet, that only he is and none of us are. I mean, that is humility and abject humility. You will never say that. Otherwise, why would you seek forgiveness for whenever someone dies? Please forgive his sins. Do we ever say he's entitled to Jannat and Allah Ta'ala grant him Jannat? He never committed a sin. We don't even pray that for ourselves. No honest person will say any of these things, that he's sagacious, righteous, non-profligate. Even the greatest saints in Islam were scared when they were dying, that they were scared of death because they were apprehensive of what may they be meeting in the hereafter. So I don't know, is this generally a wish list kind of situation as opposed to because otherwise everybody can, if I was filing a lamination paper and if someone says he's not of good character, I would not even challenge it. I said, I'm sure I've done something wrong in my life. Maybe I've done it wrong yesterday, so I don't know. So if you're honest and you say, right, this person is right, I am not sagacious, righteous, non-profligate, honest. I do not switch off the lights when I go out of a room. I waste electricity. I waste human resources which the Almighty provides. So where does it end then? I can bring any case into disqualify someone, and I want to save someone, I can also do the same thing.
That's why.
Should such power vest in judges and who are themselves humans?
That's why
they want a greater test for parliamentarians than they have for themselves. Does this language find mention in the oath of office of a judge? That I'm not profligate? Does it mention in the recommendations of a judge? All it says you have to be 45 years of age, practicing law for 10 years.
Could be
so we have a lower standard than parliamentarians. Why is this language then not reflected there as well? You know, let's accuse ourselves before we accuse anybody else what they are or what they are not. So either we have a much lesser test, we can't, at least I would be very scared to meet this test, terrified to meet this test. So either we don't have a similar test. So we have to read the Constitution as a living whole. And where the Constitution has brought down the acts, it clearly says 2 years, 5 years, 3 years, 2 years, or it's factual, you're not a citizen, fine, that's very clear. There is no punishment here, but you're out. So without a punishment, you're out. There's no punishment. So, but suppose a person is a citizen of Pakistan, not a Pakistani citizen, but becomes a citizen of Pakistan later. Would he stand disqualified for life? Suppose he filed a nomination paper and he had another nationality or whatever, and he got disqualified. Is it disqualification for life? And then subsequently he said, okay, I've surrendered my US nationality and now I want to contest. So I don't know, we have to read it in a way that is meaningful. And we must bear in mind the conditionalities that were imposed to exclude people from this, the degree situation. Thankfully, it wasn't there when the Qaid was around, because he would have been disqualified.
That's right.
He wasn't a graduate.
Amendment कब हुई? ये amendment
2002 की 8 की
2002 में
तो किसने की amendment?
My lord, this is presidential order.
क्या वो president खुद इन पे उतर सकता था, इन तमाम requirement पूरी कर सकता?
But ये general military general ज़ियाउल हक
नहीं होते, बाद में डिग्रीज करते हैं, शुरू में नहीं होता है।
नॉन इलेक्टेड मेंबर्स अगर अमेंडमेंट करेंगे तो यही होगा।
Mr. Attorney General, the question is that while we're looking at D, E and G, which to my mind appears to be a guideline for the voters, the actual gatekeepers, and they might keep this in mind when they're voting because nobody can execute them and put anybody behind anything. So D, E and G to sir guideline ho sakti hai voters ke liye, and that's never been agitated. The $1 million question is, how do we look at the line no declaration to the contrary by a court of law? What do we do with this? I mean, this is in the Constitution.
If I may,
I think my lords have raised the questions. Can we read the law on declarations? What is the law on declarations? Section 42 of the
Section 42 of the Specific Relief Act.
I would imagine, is that the only declaration that has been indicated here?
There's no other declaration. और तो कोई है ही नहीं.
कोई और law होता है declarations का? Specific Relief Act.
Only Specific Relief Act, Section 42.